Hi, my name's Judith Ray, and this is Solomon. Hello, and we're here to participate in the 94 Days of Reconciliation campaign for Canadian Roots Exchange. I'm a volunteer on the board of Canadian Roots Exchange, and I think between me and Solomon together, our average age basically makes us equivalent to a youth. We're here to tell you about Call to Action number 26 of the Truth and Reconciliation Commission on Indian Residential Schools. The Truth and Reconciliation Commission made, of course, a number of calls to action about how to move forward from the serious legacy of residential schools in Canada. And their 26th call to action is about something called a limitation period. A limitation period, what is it? A limitation period is a rule that comes from the legislation made by federal and provincial and territorial governments. And it's a rule in their laws that gives a strict time limit on when you can bring a lawsuit. Often the time limit is 2 years, and in rare cases it may be a bit longer, but it's a strict deadline. And if you bring a lawsuit after the time limit, then the defendant, which might be the federal or provincial government itself, or it might be someone else, they can have your case thrown out automatically. So if you're past the time limit when you bring your case and that limitation period is there, then your case gets thrown out on the technicality without the court ever hearing the merits of the case. You don't get to have your day in court to look at the real issues that you're trying to bring forward in the lawsuit. So what did the Truth and Reconciliation Commission say about that? I'll paraphrase their call to action 26. And in that call to action, they called upon the federal, provincial, and territorial governments to change their statutes of limitation, their laws, to make sure that the governments and others cannot rely on limitation periods to defend and throw out legal actions of historical abuse brought by Aboriginal people. I think this is extremely important. And I don't say that just as a lawyer, but I say that as something that everyone should understand is important for Canadians. Why is it so important? Well, there's lots of good reasons why Aboriginal individuals and nations as a whole typically can't bring a lawsuit immediately. Things like poverty, trauma, cultural and language barriers, lack of access to information and research to substantiate the historical claims, all sorts of things. For these sorts of reasons, it may take a long time for Aboriginal claims to actually reach a courtroom. But if there's a limitation period, it means that Aboriginal people lose access to the courts to try to resolve the important issues and important abuses that have been committed against them, just because those abuses occurred or even just started more than a few years ago. If there's a limitation period, the case is automatically thrown out on the time limit issue, no matter how valid, no matter how serious and how important the actual claim is. And not only is it thrown out of court, but if the other side in the case, that might be the federal or provincial government, if they know that the case would be thrown out in court, oftentimes, in my experience, they will not be interested in negotiating a resolution as well, because the pressure to do that is not there. So this was a real issue in the residential schools claims, because survivors of residential schools were often not ready to see a lawyer and come forward with their claim until many years after they had actually been at residential school. And it's also an issue with many other types of issues facing Aboriginal people, many other injustices. I often see this firsthand in my work. I work as a lawyer for First Nations, often the First Nation as a whole. And limitation periods are a real barrier in all kinds of legal wrongs that are faced by Indigenous Canadians today. Issues like land losses, treaty issues, rights issues, systemic abuses of all kinds. So I think this call to action is very important, and personally I joined the Truth and Reconciliation Commission in calling on the federal, provincial, and territorial governments to implement Call to Action 26 right away. It's really not in anyone's interest to push Aboriginal people's legitimate issues aside and to leave their claims without access to the courts. This issue is a technicality in one sense, but to fix it is really not a technical issue, because it's a serious issue of justice. Because if claims are thrown out on a technicality and there's no place to resolve claims, then the problems we have as Canadians, the problems facing Indigenous peoples continue to fester, the injustices continue, and the peoples of our country continue to be driven further apart. So that works really directly against the goal of reconciliation. As a country, I think we need to face up and address the wrongs committed against Aboriginal people, and sometimes that means hearing cases in court, or at least having that opportunity, so that people are motivated to come to a table and really resolve those issues. I don't think we should be placing artificial barriers and these kinds of technicalities in the way of Aboriginal claims that make them unresolvable and just shut the door. So let's get rid of limitation periods when it comes to resolving Aboriginal claims. Thanks very much. Signing off.